Welcome into this edition of The Current Report, our weekly roundup of what's happening in the world of digital media. I'm your host, Chris Clear. We're now in the third and likely final week of Google's landmark antitrust trial over its alleged monopoly from its digital advertising business. Judge Brinkema, who's presiding in the case, has kept things moving swiftly. Right now, Google's in the middle of its defense after the government opened the trial by presenting its case for the first 2 weeks. The tech giant started its defense by sharing a chart showing off the entire adtech ecosystem and its place within it. There were so many weaving, interconnected lines on this chart that the judge called it a, quote, spaghetti football. To get more insight on the trial altogether, Damian Fowler spoke with attorney Tom Blakely, who's been covering the trial and writing articles for the publication Big Tech on Trial.
So, Tom, thanks so much for joining us on the Current Report. And now you've been covering this trial for Matt Stoller's Big Tech on Trial. Could you give me a little bit more perspective about, what you're writing and what your focus is?
Sure. So I've been focusing on the case, I think, generally from a pretty neutral perspective. I was really curious to see what would happen here. I didn't really come into this with any sort of bias one way or the other, although I think a lot of people looking at this case do expect Google to lose. There was a Wall Street Journal article that came out recently that said that analysts are already valuing in a loss to Google's valuation to their stock price. It is the case that the evidence against them is pretty overwhelming. There have been a lot of smoking gun emails and exhibits and in various moments of testimony in this trial that have looked pretty bad for Google. Google started their case on Friday after 2 weeks of the government's case, and they began, I wrote about this in my article that just came out over the weekend, where they had this really messy exhibit. They basically had this Google executive draw his perception of the ad tech ecosystem, as they called it, on the fly, and it just didn't seem to go over well. And as time has gone on, it's become pretty apparent that the strategy for the government is to allege that Google has a monopoly in online web display ads. So display ads distinct from, video ads, other kinds of advertising. And it make this what's known as a tying case. So in antitrust law, you have the issue of tying, where a company is sort of illicitly forcing customers to purchase one of its products in order to purchase the one that they actually want. So in this case, if you want to use DF, and there's kind of a series of ties. If you want to use DoubleClick for publishers, also known as DFP, you have to use AdX. If you want to use Google, it's extraordinarily difficult from a technical standpoint, as the testimony we've heard in this case has revealed, to use a competing ad exchange. So there's all kinds of ways that it's been put on display in this trial that Google makes it very difficult to not use its suite of products and to divest yourself from the massive amount of scale that Google has. On Google's side of this case, Google, particularly given how quickly Google is going to present its case, is really not going to affirmatively challenge that, which is pretty surprising. I came into this kind of expecting to see Google's lawyers, who are, some of the most expensive lawyers there are, come in and guns blazing, challenge the government. But instead, what it looks like Google is doing is trying to make this into what's known as a refusal to deal case. And so what that means, if you apply that analysis, Google's saying, well, you can't tell us that we have to work with our competitors.
Now, going back to the case for the defense, I know you said it started last week, and based on maybe some of the opening arguments that Karen Dunn made, do you have any clue in terms of, the actual trajectory, as it were, of those arguments, where it might go? You did talk about it in the opening, but any other hints?
It does seem like what we've seen and what we now know, based upon the fact there might be possibly 48 hours left in this trial, is that there's just simply no way Google is going to be able to affirmatively challenge all of the evidence that the government has laid out. It seems that they have made a strategic decision to make this a different kind of case. There's this expression in the law that I wrote about in my article. Now, I'm from Boston. This might be like a Boston expression, because some other lawyers I know hadn't heard of this, but there's this expression where, if the law is on your side, pound the law. If the facts are on your side, pound the facts. And when neither is on your side, you pound the table. And it seems like what's been going on here is the government has heavily pounded the facts. I mean, you have these emails from Google that I think a lot of people have heard of by now, where Google executives are comparing their position in the ad industry to if Goldman Sachs and Citigroup owned the New York Stock Exchange, the infamous Jonathan Alec email. There's been some others that have been put on display. And so you can see how Google has some bad facts in this case. So they've been focused more on a narrower interpretation of the law, trying to make this a refusal to deal case instead of a tying case. And, I think also putting some faith in the fact that if, they lose, which it does seem like people are expecting that and Wall Street analysts are anticipating that, then when you get to an appeal, in the U.S., federal court, state court works a similar way for the most part. Appellate courts are more concerned with legal questions than factual questions. So if you kind of make two-dimensional a lot of the really bad facts for Google, Judge Brinkema will ultimately be the finder of fact in this case, and they can sort of sit there in a more academic context and say, well, you should apply this approach instead of that one. You should apply this case instead of that case, and start to get away from just the, I think, at times overwhelming testimony that we've heard, and make this more nuanced and technical and narrow. You try to fight hard, on remedies to maybe get a remedy that's more beneficial to Google. There can be ways to kind of look at that as being, more advantageous for Google, certainly than some of the really impressive testimony and evidence that we've heard so far. So it does seem like their strategy is to kind of win on that ground as opposed to trying to challenge everything that the government has put forward.
One of the things that I've noticed especially from adtech wonks is the fact that this trial has shone this light, speaking of technical, it's shone a light on some of the more arcane elements of the whole adtech supply chain. To what extent has it been a sort of education in a way for everybody, this trial?
Yeah, so I think I will say I come into this as a lawyer. I've worked in big law. I worked in the DOJ before that. I don't come into this from the media industry, so I've been learning a lot as I've been there. I think the other folks, the first day the courtroom was packed. It's since, you had a lot of different media outlets there, news cameras out front. It's since died down a bit. I will say on Friday, it was pretty packed again because that was the first day of Google's case. A lot of people wanted to see that. But it does seem like you have a combination of industry press, so like media, ad industry, people for whom that's their beat, who have been there fairly regularly. You've had a lot of lawyers there for interested parties, which basically just means other big companies that really have an interest in what ends up happening here, who want to know what's going on, what testimony is going over well and what isn't. But for myself, who comes to this from the outside, I've learned a lot about advertising, and I think it might be a similar experience to if other people more generally were to also kind of understand what's going on here, which is that you see how advertising, at least in this case, doesn't really even seem at all much like an advertising business. It's something that's much more similar to a stock exchange, which has been a lot of, I think some of the testimony we've heard, witnesses have basically attested to that the plumbing of the ad tech ecosystem is so massive that at a certain point, it really no longer becomes an advertising business.
So finally, you say that this trial may wrap up this week. Will we hit closing argument this week?
No. So just like the first Google antitrust trial from last fall in the District of Columbia before Judge Mehta that involved a monopoly in Google search, in that case, Judge Mehta decided to have a break between, each side resting its case and when the closing statements were. Judge Brinkema indicated last week that she is going to do the same thing. So we can expect that there's going to be a month, a couple months, however long it ends up being, it hasn't been set yet, for when those closing statements are going to end up being. Judge Brinkema indicated that she's going to allow them to be much more substantive than opening statements, which she limited to half an hour. In that case, each side is going to come in, maybe it's an hour, and sort of tie up the case, argue why, they should win. I think it's going to be interesting to watch that. I think it might be more interesting for Google, just because Google, we sort of know what the government's case is. I'm kind of more curious what Google's arguments are, and so we can kind of see them pull that together. And then a few months after that, we're going to get some kind of opinion here, which, I think just to temper expectations, no matter what happens, I think everyone agrees this is going to get appealed. It's going to be years before this finds some kind of final resolution, but thus far it does seem like the government has had superior facts, and I think the people's approximation of where this is heading has seemed to be correct.
Well, Tom, thank you so much for those insights, and thanks for sharing, and good luck with the rest of the trial.
Right, yeah, of course. Thanks for having me on. It's been great to talk about it and to cover it. And it's certainly an important one that could shape where this industry's headed.
Next, we're capping off this episode with one last thing. It's well known within the ad tech space that media fragmentation can make measurement a headache. But T-Mobile's VP and head of sales, marketing, and distribution, Kevin McGurn, thinks that there's a convenient solution to that problem, which he shared on our 5 Minutes With video series.
I think the same technology that fragmented everything actually has the connectivity and the architecture to unify it from a measurement standpoint. It's an industry problem that needs to be solved by the entirety of the industry, not one walled garden, not one monopoly. It has to be solved by a third party that has an unbiased approach to it.
To watch the full episode with Kevin and our editor-in-chief, Stephanie Patrick, head to thecurrent.com or The Current's YouTube channel. And that's it for this edition of The Current Report. For a deeper dive on all these stories plus more, check out thecurrent.com. And of course, please like and subscribe on YouTube, plus leave us a review on Spotify, Apple, or wherever you listen. And if you want to hear more from The Current, listen to The Current Podcast, where we interview some of marketing's biggest leaders about their keystone career moments and where the industry is going next. We'll see you next week.